Hello friends, a very warm welcome to Ansarkari, and in today's session we are going to pick up those important areas and dimensions which have shaped the understanding of not only prelims but also mains and the interview. The first topic is about India won't be accepting Pakistan nuclear blackmail. So what it means? It means that the Prime Minister says that we are going to fight. We are going to create our understanding, not only with us as a citizens, but also with the whole world. So that is why what are the key words over here? Just I'm going to pick up keywords for you, which are very, very important so that we can create a new understanding. If there is a terrorist attack on India, a fitting reply will be given. India will not tolerate any nuclear blackmail. We will not differentiate between government sponsoring terrorism and the masterminds of terrorism. Now, this is the only great takeaway. So I would like you to answer what do you think makes our Prime Minister so confident that he is taking up such bold, courageous, honest, and transparent measures. Second point is with respect to India and Pakistan DGMO, they agreed to reduce troops on borders and more visual evidences of Indian air defense and the damage to the Pak bases is being shown. That is fine. And first time India is naming China as supplier of missiles by the Pakistan, and it is showing reverence. So why do you think India is name calling China? India is shaming China, and like the way it is done with Turkey also. Do you think it is really a great idea to do so? Secondly, Prime Minister is saying that we will not accept the Pakistan's nuclear blackmail. Why do you think so? That we must not be bothered about the deviant and ill-mannered and delinquent behavior of Pakistan because it has such a history. Moving further, Prime Minister is saying that we are unveiling a new doctrine. So if I ask you about the India security doctrine post post strikes in Pakistan, post Pahalgam and pre Pahalgam, so do a comparative assessment of Indian security doctrine in the pre and the post scenario with 5 points each. Pakistan air bases have been hit very badly, so it is shown over here. Rawalpindi, Chakwal, Sargodha, Sarkot, Jakowawad, Sukur, Rahim Yar Khan, Chunian, Lahore, Parsoor, and Sialkot. So this is the whole point. You must read it for your own awareness. Though I am very sure no question can be there in the examination, but understanding these air bases, radar sites, and air defense units will give you more confidence, will make you more happy, and you will think about the glory of our nation. Why do you think US and China have agreed to temporarily slash tariffs? Because this was going to be there because both are interdependent on each other and they are actually, were in the situation who is going to blank the eye first. So there is truce because tariffs are not the solution to trade imbalances. US wants to reduce trade imbalances, and that is not the way. And the consumers are spread over a large number of countries and not only just US and China. The US economy has started wilting under the price pressure of tariffs, and that is why there was a genuine risk if the truce would not have been announced, the shelves in retailers such as Walmart would have been very empty. That is why US economy is contracting. Trump wants it to continue. So no country has won the tariff war actually, but China has managed to get the better of the US. That is very true. So there will be immediate impact. Both the countries are again ready. So this is not a deal, it is a truce. That's what we can say. Government keeps data exclusivity out of FTA with the UK. Now this is the second FTA where pharma data exclusivity is extended. That means we are protecting our generic pharma industries by keeping out data exclusivity provisions from the free trade agreement. And UK was trying that we must include it so that they can get more benefits. But the Indian generic drug manufacturers, they would have suffered. We would have suffered. That is why what we can say, according to Indian laws, in which is allowing to use the data of clinical trials by the companies to launch copies of the drug that go off patent. This is reducing time and cost for the generic manufacturers to go to the market. अगर वो generic companies are going to generate the same data, it will take them at least a decade and more time. So during the negotiations, UK was asking to include the provisions in the trade pact, but India has not accepted that. So there is no fear. In fact, there is a bright spot, and if exclusive rights over this data would have been given, so innovator companies can prevent their competitors from obtaining market license for low cost versions. That is why it is very, very important and a good step when India had done uh, uh, FTA with the four nation European Free Trade Associations. Then also India did not accepted that. Iceland, Liechtenstein, Norway, and Switzerland. Switzerland is the hub of most innovative companies in the healthcare. Even they did not get it. So we are on the track. You must know about the role of trade-related intellectual property rights coming under WTO. Similarly, here also government seeks first right to buy oil and gas under exigency clause. So that means government is going to have a preemption rights over all crude and natural gas produced in the country in case of national emergency. So the fact that preemption right is a legal right of a party to buy or acquire a certain product or asset or resources into existence. It can be offered to to any other person or entity before it can be offered there. So that is why the proposed regulation comes that the government seeks to ensure adequate stock and availability, whether it is CNG, whether it is PNG, whether it is fertilizer or paint. And in case of national emergency and adversities, it is going to take the first step. So this is a very, very positive sign. This is in the self interest of the nation, and fair market price is prevailing at the time of preemption shall be paid to the leasee by the government. So we are not running away. We are supporting it, but then we are having a choice. So private players in the country's upstream sector have time and again said the price discovery should be better in the global markets. So that is why you can say we are moving towards such understanding. But the rule also says that if a leasee fails to meet the lease obligations due to force majeure, the adjudicating authorities cannot impose penalties. That means if they are not able to support beyond their own control, then nothing can be done. An act of God, war, insurrection, riot, civil commotion, tide, storm, tidal wave, flood, lightning, explosion, fire, earthquake, pandemic, any other happening with the leasee could not reasonably prove. So this is something which is coming uh, with the passing of the Oil Fields Regulation and Development Amendment Bill 2024 in an attempt to make oil and gas exploration in the country more attractive for the company. Now we have already spoken about solar SECI, Solar Energy Corporation of India. We had already spoken about in the context of Adani Group also. Now it is in the limelight because of wrong reasons, has made a major headway in the recent years. The agency's name surfaced in the US indictment of Adani Group that I already told you, and especially in Andhra Pradesh context. And conglomerate made the pay out to secure power purchase agreements for its solar energy project. There was another row over the submission of fake documents by the Reliance Power to SCCI for an RE project. So that is why it is asking for due diligence. It is asking for positive governance. It is asking for corporate ethical behavior. It is asking for the role of Ministry of Corporate Affairs, and then only you can say that SECI will be able to play its role more pertinently. And it has definitely got a very, very important role. इस context में मैं आपसे कह सकता हूँ you have to write a short note on the nature and the objectives and the challenges faced by SECI. Now, a very important article is there by Amol Agrawal, who teaches at Ahmedabad University. So inflation targeting has its origin in New Zealand, it is saying in 1990. And after World War II, the focus of the world economy was to restore development and growth. The policy was buttressed by the findings of New Zealand economist Alban William Housego, that is Bill Phillips. His Phillips curve shows that there was a trade-off between low inflation and low unemployment. Very important for the prelims. So government could choose between growth, employment, and inflation seamlessly. In 1970s, global economy faced supply shocks due to high inflation and high unemployment. Milton Friedman and Edmund Phillips had warned even earlier that trade-off was at best over a short run. Over the long run, Philip curve was vertical. So they argued high inflation feeds into inflation expectation and becomes a spiral thing. वो होता जाता है cyclic तरीके से. Central banks were ready to control inflation by targeting money supply. But banks struggled to target money supply as innovations in payment systems kept broadening the definition of money. That is true. That is what is happening. And the search for a new system led to sudden discovery of inflation targeting in New Zealand. So New Zealand was suffering from low growth and high inflation. Newly elected Labour government, they are giving it in the history. So specifying clear targets, granting autonomy, holding accountability. So that is how they were able to do it. And Mervyn King, former Bank of England, noted that ITF, a case of practice, a case of practice before the theory. So ITF was highly successful as it established a new set of monetary procedures and institutions. The communication policy of central bank became, ITF means inflation targeting framework, became highly transparent. It transformed from highly opaque and clandestine to transparent open. Same thing has been done with India. So that is why the seeds of inflation targeting framework were planted across the world. Many central banks, and they are doing it. For example, Canada, Australia, UK, and Sweden, they were more prone to monetary shocks. So, in crisis also it was adopted by Czech Republic, Poland, Southeast Asian nations, and then so forth. The bank have inflation targets but do not call themselves inflation targeting central banks due to broader mandates. India adopted ITF in 2015 after much deliberations and discussion what took place with RBNZ Governor Dolan Brash and LK Jha lecture 1999 and ended with Urjit Patel Committee 2040. So that is why we are saying, so it is natural that inflation targeting framework will lead to wide introspection, जैसा कि हमने बात भी अभी की, और उससे हम देख सकते हैं कि हमारी ग्रोथ की ट्रेजेक्टरी किस तरफ गई. How states are getting their act right? Some states are getting their act right. Fiscal ranking, scoring better, revenue deficits being controlled, interest payments, and debt management. Telangana and Tamil Nadu perform well in SHG loans and bank credit disbursement. This is very good. And Bihar and Jharkhand have been down because of financial development and social pillars. And within financial development, Bihar scored poorly in terms of bank credit disbursement, loans by self-help groups, penetration of mutual funds, health and insurance. And among the social indicators, the state lags the gross enrollment ratio, multidimensional poverty and literacy, poor performance across most pillars, weighed on composite score of Jharkhand. So the state specifically lagged in infrastructure and environment pillars. That's what we can say. Goa is leading among the smaller states, we know, because of tourism, having per capita power availability, penetration of financial products, completely urban, good doctor availability, better outcomes in infant mortality. So we can think better that that's how it is taking place. From slum in Amravati, Delhi, Justice Gawai's road of becoming CGI. So a wonderful and an inspiring example. Kamlatai, mother of Justice B.R. Gavi at her home in Amravati, she is there. Look at the way, the simplicity, and also the traditional setup, and the municipal school in which he studied till class 7. So Justice Gawai is a role model for all of India, where things definitely move and everybody gets their chance, provided you are honest, consistent, and also you are putting your best. Public declaration of assets of judge is a good step, but transparency needs more. तो आप क्या और चाहते हैं कि आपके हिसाब से होना चाहिए था जो ये नहीं है? And transparency is coming after the issue of the cash scandal which took place. Judges enjoy enough immunity. They are not totally shielded from accountability. The Judges Judicial Officer Protection Act 1850 states that no judicial officer will be subject to a trial before any civil court for any act done in the judicial capacity, if done in good faith. Similarly, Judges Protection Act 1985 states that no court can entertain any civil or criminal proceedings against any judge in India for any accusation pertaining to their judicial duty. However, this is not absolute in nature, because Act also states that this is not debarring from any lawful authority from initiating any action against someone, जैसा कि अभी किया गया, if the charges relate to them as individuals and goes beyond the adjudicatory or administrative. So 1991 का के वीरास्वामी केस जो था, उसके अंदर अपेक्स कोर्ट ने बोला कि नो क्रिमिनल प्रोसीडिंग अगेंस्ट जज ऑफ द सुप्रीम कोर्ट और हाई कोर्ट विल बी रजिस्टर्ड विदाउट कंसल्टिंग द चीफ जस्टिस ऑफ इंडिया. इतने सारी पावर्स. Article 124 and 218 establish the process of removal of judges on the grounds of proven misconduct or incapacity. मोशन पास किया जाएगा दोनों हाउसेज ऑफ पार्लियामेंट में स्पेशल मेजोरिटी से, एंड inquiry is initiated against a judge and internal committee led by CJ, जैसा अभी हुआ भी, or the relevant high court oversees the matter and decides appropriate. The outcome is, if the however outcome is not made public and general compass of the punitive measure extend to transfer, resignation or non-assigned to judicial. तो इतनी इम्यूनिटी क्यों दी गई है? ताकि आप इम्पार्शली, आप देश के लिए, लोगों के लिए सत्य और न्याय के साथ काम कर सकते. But judges around the world are also not immune to civil and criminal prosecution. US, Argentina, South Korea, and Russia are among the countries that have made it mandatory for judges to declare their assets. Canada and UK, like India, have non-mandatory declaration system. Details जब दी जाती, जब पूछा जाता. US, UK, Germany have special legal procedure to try judges. Canada has judicial council. Push for financial disclosure is also endorsed by international standards like Bangalore Principle of Judicial Conduct. Very important point. सिर्फ वेल्थ ही नहीं बतानी चाहिए, बल्कि उनको ये भी डिक्लेयर करना पड़ेगा कि कॉन्फ्लिक्ट ऑफ इंटरेस्ट नहीं है, जुडिशियल इंटीग्रिटी हमारी है. सो फाइनेंशियल डिस्क्लोजर इज अ क्रिटिकल स्टेप टुवर्ड एम्ब्रेसिंग ट्रांसपेरेंसी. लेकिन जैसा हमने कहा कि आप ये बताइए कि और आप क्या सोचते हैं कि जजेस को करना चाहिए, ताकि जो जो इतना बड़ा इंस्टीट्यूशन और इतनी जो सैंक्टिटी है वो उसकी बनी. So with these ideas and words, with little brief understanding, we wind up for the day. But you please make sure that you write questions, bring out some curious thoughts, and we can discuss further. Thank you very much.